Just hang around. Oh, yeah, under something we heard from Tip. Oh, we didn't have no problem with Jessica, so I don't know who got him. All right, good morning, everyone. I'm Judge Eric Morrow. This is the Orca 9 o'clock Orca motions calendar. Let me go ahead and call the calendar to see who's with us this morning. Position number 1, Christopher Bennett.
Yes, Your Honor, I'm here.
Good morning, Mr. Bennett.
Morning.
Mr. Spiesman, you expect him to be with us this morning? Is that your attorney?
Yes, Your Honor, he is. I expect him to be here.
Okay, I'll hold for his announcement. Thank you. Position 2, Christopher Cahill.
Good morning, Your Honor. Thought we were gonna have this worked out, but we're ready for motions.
Okay, good morning. Position number 3, Shak Labarthi.
Judge, good morning. That's my case. We're here. We're ready.
Good morning, Mr. Muscala. Position 4, Terrence Johnson. Terrence Johnson. Position 5, Thomas Whitmore.
Your Honor, I'm not sure where my attorney is.
Okay, good morning, Mr. Whitmore. I'll hold for their announcement. And we have at least from the afternoon calendar, Brianna Alston. All right, let me go ahead and take this. Are you here on the case?
Yes.
Randy, didn't we have some other add-ons that or is that tomorrow?
Yes, did you? Yes, it is, Anna Montagli. Oh, that is a matter that I believe, Ms. Riser will be handling.
Okay, were they supposed to appear in person or were they supposed to be on?
Okay,
But she will, Ms. Liza will be there.
she will, okay, so yeah, that was the add-on, that, it was supposed to be before Judge Lofton, she said.
Were they supposed to be in person or on Zoom?
If I had paperwork, it was supposed to be on Zoom, but I don't have any paperwork.
Okay.
So let me double check.
Are we ready to take the plea on Mr. Bennett?
Hey, Judge, good morning. Sorry, I was a minute late.
Oh, don't worry about it. I see that you're here. Good morning.
Thank you. Good morning.
And who's presenting for the state on Mr. Bennett?
My case, I'm just looking for.
Okay. Good morning again, Mr. Bennett. Can you raise your right hand for me?
Yes, Your Honor.
You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes, sir, Your Honor.
You can put your hand down. Whenever you're ready, Ms. Waldron. Set. Only she needs it.
It's sticking to 1 count of reckless driving. The state has, I believe, already tendered a null clause on the count of failure to maintain lane as well as the count of aggressive driving. With respect to the reckless driving charge, the negotiated sentence is for 12 months, balance probated, to pay a $300 fine, complete 40 hours of community service, risk reduction, and alcohol and drug evaluation, and any treatment being necessary. Victim impact panel, as well as defensive driving. There's no objection to early termination upon completion of condition stretch.
Counsel.
Thank you, Judge. We'd ask that you accept a negotiated plea. It's a first offense DUI, no arrest after this date. And we'd ask that his probation terminate once he completes all conditions.
Mr. Bennett, it's my understanding that in case 21 CR 002278F, you wish to plead guilty to reckless driving. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir, Your Honor.
I'll accept the plea as negotiated. Let's see, as soon as you complete the terms of the probation, it will terminate. We'll get you where you need to report to probation if you can report within the next 2 weeks. Anything further for Mr. Bennett?
Nothing, Judge. Does he need to wait on probation or should he expect a phone call from them?
We'll get you the paperwork regarding where he
Okay.
needs to report. They're not with us this morning. But we'll get you and Mr. Bennett the paperwork for that.
Okay, Judge, I'll wait to hear from you guys and we'll get you whatever you need.
All right, very good. Have a good day.
Thank you, Ms. Bennett. You can sign off.
Thank you.
Let's see, where do we have a court reporter? Court reporter?
Yes, I'm here.
Oh, good morning, Miss Allen. Thank you.
You're welcome.
Thank you.
Are we ready on position number 2, Christopher Cahill?
Your Honor, we are waiting on investigator Lambert on that case. I'm gonna give him a call and just get a ETA, but I do expect.
We're ready, Your Honor.
Okay, thank you. Are we ready on position 3, Chakravarti?
Your Honor, we are still trying that case.
Okay. The Terrence, position 4, Terrence Johnson.
Your Honor, I don't see the defendant in the courtroom. I can call the attorney. I have his number. Try
Okay.
and see where he's at. And then for position number 5, Thomas Whitmore, the attorney Thomas is in the courtroom and we'll pre-trial remote and come back with an announcement.
Okay, all right, so I guess we will be in recess until someone shows up or you all give me an announcement regarding your pre-trials.
Thank you, Your Honor.
Okay, court is back in session. The court calls the case of the state of Georgia versus Christopher Cahill. Case number 21 CR 006793F. Council, can you make sure that microphone's on? Okay, very good, sir. The council will, for the record, will announce themselves, please.
Mark Hansford for Christopher Cahill.
Good morning.
Angela Waldrop for the state judge.
Are you ready to proceed, Ms. Waldrop?
I am, Judge. If we could just narrow down and outline the motions issues prior to starting. And then
Okay,
ready to go.
Your Honor, in my motions, I filed the reasonable articulable suspicion for a stop, a prolonged stop, probable cause. I know this, Ms. Waldrop reached out to me before and agreed that the refusal to the breath test is out because of Elliott. I'm not sure if she's agreeing that the refusal to the Alka sensor is out under Ammons.
It is.
And then probable cause for the arrest. Yeah.
okay. So again, so we've got the probable cause. What are the other issues?
Well, I think I think she's agreed that the breath test is out and the refusal to submit to the Alka sensor is out as well.
Okay, so it's only the probable.
Reasonable articulable stop, a prolonged stop issue under Hill v. State,
Okay,
and then and the probable cause for the arrest.
okay. Waldrop,
Yes, Judge. So I have those three issues noted. Agreed that the refusal to both the Alka sensor as well as the state test, breath test is out.
okay,
Understand that. And Your Honor, just before we get started, just so that the court is aware, I will be playing the video up until the point of 10:40 and stopping it because there's just dead time when the officer, Investigator Lambert goes back to his vehicle, and then starting it back up at 15 minutes, if that is okay with the court and defense counsel.
Mr. Hansford, is that,
That's fine, Your Honor.
okay, I'll do whatever you want me to do as far as,
That's fine.
okay.
Your Honor, the state would call to the stand Investigator Lambert.
Good morning.
Good morning, sir.
And is the court going to swear him in or?
Yes, I do.
State the name for the court.
Daniel Lambert.
Good morning, Investigator Lambert.
Good morning.
Can you tell the court a little bit about what you do and where you work, please?
I work for the City of Alpharetta Police Department. Been there for 23 years this week. And I spent 19 of those years in the traffic unit, 13 of those years on the DUI task force, and a few of those years on the accident unit.
Okay. And is 20 years your total law enforcement experience?
28 years is my total law enforcement experience.
Okay. Where were you employed prior to Alpharetta?
Your Honor, we'll stipulate to his training and as an officer and all of his training as far as DUIs are concerned.
Okay,
We'll stipulate.
so stipulated.
Okay. Investigator Lambert, do you recall being on duty on March 5th of 2021?
I do.
Okay. And were you working with the City of Alpharetta Police Department at that time?
I was.
And do you recall where it was that you were at that time and what you were doing?
I was working for the accident unit as a part of the traffic unit. We had 3 accident cars. I was one of those. And I responded to an accident on Cummings Street in front of Manning Oaks Elementary School.
Okay. And how were you made aware of the need to respond to this location?
It was a dispatched call for a crash on Cummings Street, which is in Fulton County.
Okay. And when you arrived, did you encounter the defendant, Mr. Cahill?
I did.
Okay, and was his vehicle already in a stopped position?
It was, they had pulled into both vehicles had pulled into the parking lot of the school.
Okay. So you did not make an official traffic stop of Mr. Cahill's vehicle, is that correct?
That's correct.
And on that day, were you in uniform to include your badge?
I was,
And were you in a marked patrol vehicle?
I was.
And approximately how long after getting the call did it take you to arrive on scene?
Probably less than 10 minutes. Probably more in the neighborhood of 5 minutes.
And before I get into your encounter with the defendant, one question, Cumming Street, this particular location, is that in Fulton County?
It is in Fulton County.
Okay. And on that particular day, was your police patrol car equipped with a camera?
It was.
Okay. And is it routine for a Alpharetta police car to be equipped with a camera?
It is. The marked vehicles are, yes, ma'am.
Okay. And was your uniform equipped with a camera?
It was.
Okay. And is that routine for your uniform to be equipped with a body worn camera?
Yes, uniform officers have a body worn camera.
Okay. And is your encounter with this particular defendant captured on body cam or on your patrol vehicle camera?
It is both.
And how does the body cam operate with regard to turning it on and off?
It can either be manually turned on with a remote, or it turns on if your blue lights are on and it's synced to the car once you open your driver's door.
Okay. And how does the patrol car camera operate with regard to turning it on?
It can be cut on manually by pushing a record button, or as soon as you cut all of your blue lights on front and rear,
Okay.
it starts.
Your Honor, we'll stipulate to a foundation for his body cam and any dash cam video.
So stipulated.
And when was the last time you had the opportunity to view your encounter on tape of the defendant?
I did view it yesterday.
I'm going to play a portion of a video and just ask you some quick questions.
Oh, sir. What happened?
Okay, Investigator Lambert, do you recognize the clip that I've just shown you?
Yes, ma'am.
Okay, how do you recognize it?
That is the beginning of the video for my encounter with Mr. Cahill.
Okay, and is it an accurate depiction of your encounter with Mr. Cahill?
Yes, it is.
Does there appear to be any material alterations or deletions to the video?
No, ma'am.
Okay. Your Honor, at this time, state would tender into evidence the body cam of Investigator Lambert.
No objections, Your Honor.
Tender without objections.
Thank you. When you initially arrived on scene, Investigator Lambert, what did you see?
There was a white Dodge truck. I pulled up behind it, and then in front of it was a Nissan Rogue, and the two parties were standing outside the vehicles.
Okay, and who did you initially encounter?
Mr. Cahill first, because he was in the vehicle closest to me.
Okay, Your Honor, at this time, I'm going to go ahead and play the body cam.
You go east or west on Fifth Street? No, east. East on Fifth Street? No. Yeah, what happened with the cup? What's these done? Rolling. What's your one? Where you came from? Yeah.
You're good. I got the, 400. Expired, but. Big problem. That one is gonna be, that was, part of the hotel. So. Hotel, let me see. Yeah. There's no hotel. No. All right, so we were, all 400. Actual hotel, and actual, like, the there, which is going to be, burning. So. Okay. So, what did you approach? Yep. One. So right there, we're not looking at anything. You said, okay. No, okay. Okay. So what name tells you, so you're going to hurt? That. Also, stop to work. Yeah. Yeah. Stop to. Okay. Let's go to here. What's your name? You know, we like to do that. What's your name? So you're MERT. ER. What's your husband? What's that? HER. What's your name, brother? The year? You have an ID important? Or some question? Can you have a with you? Yeah. Let's see if we can find it. It should be.
Yeah, I don't. Make a motion to pass. A motion. So.
No, I can, put it forward to you. And just for the record, the video is sped up to 8:49 seconds, 8 minutes, 49 seconds. Thank you. And I'm going to skip 15 minutes.
Yeah.
Yes. That's what. If you're not aware it is.
Yes.
You know, and when it's not that there, it's really not going into any further issues prior to what was requested after you. Investigator Lambert, I think you to ask you, were you first certified in this date of March 5th, 2021?
I was,
Um, we speak of that video, that you let the other driver, well, first of all, on the video, the defendant was already outside of the vehicle when you were by the scene, is that correct?
yes, ma'am.
Okay. How did you establish that he was the driver of that white truck?
He said he was driving.
And we saw at about 17 minutes, 20 seconds that you allowed the other driver
Leading questions.
at approximately 17 minutes, 20 seconds. Did you conclude your investigation of the actual accident?
Is that when I let the other driver go?
That is when you let the other driver go, correct?
Yes, ma'am. I concluded my dealings with her and had to go deal with the defendant at that point for what I believed he was under the influence of DUI.
Okay, and who did you determine to be at fault for the accident?
I did determine him to be at fault, Mr. Cahill.
Okay, but you did not let Mr. Cahill go at that time, is that correct?
That's correct.
Okay, so why was it that Mr. Cahill was not allowed to leave after you had ended your investigation of the accident portion of this investigation?
Because I believed he was under the influence of DUI, I believed he was under the influence and I wanted to conduct an investigation for that.
Okay, can you tell the court what it is that gave you the suspicion he was under the influence?
He had bloodshot, watery eyes. None of his statements were making sense to me. And he appeared to be swaying and unsteady on his feet while I was standing there talking to him, getting the initial information.
Okay.
And his speech appeared to be slurred at times.
Now, you had never encountered Mr. Cahill prior to this incident, did you?
Not to my knowledge, no.
Okay. So what about his speech made you think it was slurred?
It just, the way it was slow and coming out of his mouth at times.
Okay, and you stated that his answers did not make sense. You asked the defendant where he was coming from, didn't you?
Yes, ma'am.
And what did he state?
He said Marietta at first, which doesn't really make sense why he would have been on Cumming Street at that point.
Okay.
Then I continued to ask where he was coming from, and he said his hotel, which was the Hilton Garden Inn, which is the actual direction he was headed.
Okay, so the direction in which he was headed was also the direction that he stated he was coming from, is that correct?
Yes, ma'am.
Okay. When you first made contact with Mr. Cahill, how close were you to him on scene?
At first, within a few feet.
Okay. And I heard you state that you could see bloodshot, watery eyes and observe swaying. Did you notice any odors coming from Mr. Cahill?
I noticed the odor of an alcoholic beverage once I started HGM and got even closer to him.
Okay. And would you describe the odor as strong, moderate, or faint?
I just noticed an odor.
Okay. Did the odor at all indicate to you that alcohol consumption would have been recent?
It would have been that day, yes, ma'am.
Okay.
That's recent.
And approximately what time of day was this that the
It was
encounter occurred?
around 10:58 p.m.
I'm sorry, around 10:58?
a.m.
Okay.
Now, you asked the defendant whether or not he had drank anything or taken any medication, and what was his response?
At first, he said no to both, and later on, he said I believe he was indicating he was taking blood pressure medication. He said medication.
Okay. When the defendant stated no to you, did you believe him?
I knew,
Objection, Your Honor, irrelevant.
I'll allow it.
I believe something was up with the questions I was asking, his answers not making sense to me.
Okay. Did you ask the defendant to perform field sobriety evaluations?
I did.
Okay. Did the defendant agree to perform field sobriety evaluations?
He did.
What specific evaluations did you ask the defendant to perform?
Horizontal gaze and nystagmus, walk and turn, and one leg stand.
Okay. And did you medically clear the defendant to perform those evaluations prior to starting?
I did.
Okay. And what was the first test for evaluation?
The horizontal gaze and nystagmus.
What is that particular evaluation? First of all, what training do you have in that evaluation?
I am standardized field sobriety certified, or I have.
Your Honor, we'll stipulate to his training as we did before.
Okay.
So stipulated.
Describe the HGN evaluation for the court, please.
As you check the subject's eyes to see as they gaze side to side by doing a series of passes to check if there's involuntary jerking in the eyes as they gaze side to side, then there's potential for CNS suppressants or alcohol consumption.
Okay. And what is the maximum number of clues that a person can display on this evaluation?
3 in each eye, which is a total number of 6 clues observed.
Okay. And how many clues did the defendant display?
He had 6 out of 6 clues.
And did you perform that evaluation in accordance with your training?
I believe I did.
Okay. In your experience, are individuals who are not under the influence of alcohol able to perform HGN without exhibiting clues?
Yes.
What was the next test that you performed?
The walk and turn.
Okay, and describe that particular evaluation for the court, please.
You have the subject stand in a position with their left foot back, right foot in front, arms down at their side while you give them, and stay in that position while you give them instructions to take 9 heel to toe steps down an imaginary line, leave their lead foot planted, take a series of small steps to make a turn, and take 9 heel to toe steps back down the imaginary line.
Okay, and have you received training in performing that evaluation?
I have.
Okay, and can you tell the court about that training?
Your Honor, we stipulate again.
Did you perform that evaluation in accordance with your training?
I did.
And how many clues, what are the maximum number of clues on the
There-
particular evaluation?
There are 8 clues for that evaluation.
Okay, did you demonstrate the evaluation for the defendant prior to him completing it?
I did.
And what are the clues that you are looking for?
Failure to maintain balance, starts too soon, misses heel to toe, raises arms while walking, steps offline, improper turn, an incorrect number of steps. And I'm missing one. I can't think of the other one.
How many clues did the defendant exhibit on this particular evaluation?
I have 7 out of 8 listed.
Okay. And in your experience, are individuals who are not under the influence of alcohol able to form the walk and turn evaluation successfully without exhibiting clues?
Yes,
Okay. And what was the next evaluation that you performed?
the one leg stand.
Okay. And tell the court exactly what that test is.
You have the person stand with their feet together, arms down their side, and stay in that position until you give them the instructions to begin. You have them stand on either a leg of their choosing, raise one foot off the ground approximately 6 inches, toe parallel to the ground. count out loud, 1001, 1002, 1003 until you tell them to stop. And while they're doing this, they look down at the foot they have lifted, keep their arms down at their side and keep both legs straight. And you time it for 30 seconds.
Defense counsel stipulating to Investigator Lambert's training and conducting the one-leg stand.
We stipulate, Your Honor.
Did you perform that evaluation in accordance with your training?
I did.
What's the maximum number of clues that one can exhibit on that particular evaluation?
Four clues.
Okay, and how many clues did the defendant exhibit?
3.
Okay, do you recall what those were?
He put his foot down before 30 seconds. He raised his arms more than 6 inches and he was swaying.
And in your experience, are individuals who are not under the influence of alcohol able to, and otherwise medically cleared, able to successfully perform that evaluation without exhibiting clues?
Yes, ma'am.
Okay. In your experience as a police officer and in just your general life experience, have you had the occasion to observe people under the influence of alcohol?
Yes, ma'am.
Okay. How many times would you say?
Tens of thousands.
Okay. And are the manifestations that you observed on the defendant consistent with someone who had been under the influence of alcohol?
Yes, ma'am.
And based on your experience, do you have any opinion as to whether or not the defendant was under the influence of alcohol to the extent that he was less safe to drive on March 5th of 2021?
Yes, ma'am. I believe he was under the influence to the point he was a less safe driver and I placed him under arrest.
Okay. And did you place the defendant under arrest?
Yes,
Okay. At what point did you place him under arrest?
once we were finished with the evaluations.
Okay. And it appeared from the video that the total time of this particular encounter with the defendant was approximately 31 minutes. Is that correct?
Yes, ma'am.
Okay. Prior to his arrest, correct?
Yes, ma'am.
Okay. And do you see the individual that you encountered on that day, Mr. Cahill, in the courtroom today?
I do.
Okay, can you point him out to the court and describe where he's located and what he's wearing?
He's sitting in the center of the table here next to me with a white shirt, blue tie on.
Okay. Nothing further from the state at this time, Judge.
Russ?
Just a few questions, Your Honor. Officer Lambert, I've known you for quite some time. You've had a chance to watch this video and you watched the HDN. Could you tell, Your Honor, according to your training, how far is the stimulus supposed to be from the subject's face when conducting HDN?
12 to 15 inches.
12 to 15 inches. Okay. And is your testimony today that, my client and you did you have a mask on?
I did.
This was at pretty much the height of COVID at that point, correct?
When we were starting to come back around after COVID, yes.
Okay, you had a mask, and my client had a mask on as well?
Part of the time, yes.
And would that have contributed to any speech that related to your on the scene that day?
There's a possibility it could have, yes.
And one of the last things, what does your training tell you about people that are 50 pounds overweight when conducting walk and turn in the one leg stand?
That there's a possibility that they may have, because actually it doesn't give a poundage. It just says,
I'm sorry,
it doesn't give a poundage. It just says morbidly obese.
I thought it was 50.
In the manual, it just says morbidly obese.
Okay, so that could have affected it as one leg stand, or walk and turn. One last question. You never asked, you actually instructed my client to perform the one leg stand. You never asked him if he would be willing to do that, correct?
I asked in the beginning if he would do any series of evaluations and he agreed.
But when you got to the one leg stand, you actually told him how you wanted him to do that. You didn't actually ask him, correct?
Well, that's how you do it. You tell him what to do.
Well, yeah, and you didn't ask him if he would be willing to do the one leg stand though. At
Objection
that,
asked and answered.
that's not been answered, Your Honor.
Go ahead.
You never asked him to perform the one leg stand, did you?
I don't ask him prior to each evaluation. I asked him in the beginning if he would submit to field sobriety evaluations, and he said yes.
You did not suspect my client being under the influence of any drugs, did you?
In the beginning, I was not sure what the problem was because like I said, I didn't smell it alcohol until I started HGN.
Okay.
So I was unsure at that time what it was.
Because you implied consent, you asked for breath and he declined, correct?
At that point, I believed it was alcohol.
And these field sobriety tests are not, these field sobriety tests were initiated by Dr. Marcelina Burns to try to determine, predict the blood alcohol level, not impairment, correct? As you answered.
Objection, Your Honor. I think this goes beyond the scope. This is probable cause, reasonable articulable suspicion, and then the length of the detention.
Which is exactly what we're doing here. We're talking about, I'll rephrase.
I'll allow it. Go ahead.
So these field sobriety tests are not used to determine impairment. They're determined to try to predict the blood alcohol level, correct?
No, that's not correct.
That's not correct?
That is not correct. They're used to determine impairment at a blood alcohol level or more.
But these tests are set up to try and predict the blood alcohol level, correct?
The San Diego study says that, or was done to predict if it was 0.08 or less, or even less, if it would predict that they were under the influence. So it does predict being under the influence.
So I'll ask the question again. These field sobriety tests are used to predict the blood alcohol level, correct?
No.
Objection, Judge. He already answered that question.
Yeah, that's
Furthermore,
fine. That's fine. I don't have any further questions.
Just briefly, redirect, Judge. Investigator Lambert, what was the distance of the stimulus that you used in this particular encounter with defendant?
I believe it's between 12 and 15 inches. It's
Okay.
hard to see on the video from that angle.
Okay, but you did testify that you conducted that particular evaluation in accordance with your training, is that
Yes,
correct?
Yes, ma'am.
And at one point, did the defendant remove or take down his mask?
He put it up and took it down several times while I was dealing with him.
Okay, the slurred speech that you indicated you had heard earlier, did you believe that to continue even after he took down his
Objection
mask?
on our leading questions.
Rephrase.
When the defendant removed or took down his mask, did you continue to notice what you
Your
heard
Honor,
earlier?
objection, leading questions.
What did you notice about his speech when he took down his mask?
At times his speech was still slow and sometimes appeared slurred, but he also became argumentative while it was down. That was in the time he was argumentative with me, so.
Okay, nothing further, Judge.
No further questions, Your Honor.
Okay. Thank you.
Thank you.
Call your next witness.
Your Honor, there are no further witnesses from the state.
Your Honor, no witnesses for us, just argument.
Okay.
Yes, Judge, with respect to the defense's motion to suppress on the basis of reasonable articulable suspicion, prolonged detention, and probable cause, the state would respectfully request that the court deny the defense's motion. You heard testimony from Investigator Lambert of the City of Alpharetta Police Department that on this particular day of March 5th, 2021, he responded to an accident call at Cummings Street in Fulton County. This was not a stop. This was a report of an accident. He responded to the scene, conducted an accident investigation in which he determined the defendant to be at fault for following too closely behind the other driver that you saw in the video. At approximately 17 minutes and 20 seconds, he let the other driver go, and his investigation of the accident was then concluded. but he did not allow Mr. Cahill to leave. And the reason being is that he determined that there was reasonable articulable suspicion to continue holding Mr. Cahill, and then furthermore investigating him for driving under the influence of alcohol. He testified that those indicators that gave him reasonable articulable suspicion included that Mr. Cahill had bloodshot eyes, that he was swaying as he was standing and Investigator Lambert was speaking with him, that he could detect slurred speech that was also slow, and that his answers did not make any sense when he was asking him where he was coming from, where he was going to. In addition, he noted that the defendant had the odor of alcohol coming from him. And he asked the defendant to perform field sobriety evaluations in order to determine whether or not, in his opinion, as an investigator with 28 years law enforcement experience, whether the defendant was less safe to drive. The defendant agreed to perform those evaluations. You heard testimony that Investigator Lambert administered those evaluations in accordance with his training which defense counsel stipulated to. And the results of those evaluations with respect to the HGN evaluation was 6 out of a total 6 clues. And on the walk and turn evaluation, it was 7 out of 8 possible clues. And then furthermore, on the one leg stand evaluation, it was 3 clues that the defendant showed out of a total of 4 clues. You heard testimony from Investigator Lambert that indicated to him that the defendant was less safe to drive, and that as a result of his opinion that the defendant was less safe to drive, he arrested the defendant for DUI. Your Honor, as we know, the standard for probable cause is low. You only need a little bit of evidence to show that it is more probable than not that that is what occurred, that the defendant was under the influence of alcohol. Here we have not only the manifestation, the physical manifestation of the defendant, Mr. Cahill, but we have an accident in which he was determined to be at fault. So we have a less safe act. And then, Your Honor, we have his performance lastly on the field sobriety evaluations. The clues which he showed were almost at the maximum, 6 out of 6 on the HGN, 7 out of 8 on the walk and turn, and 3 out of 4 on the one leg stand. With respect to reasonable articulable suspicion, Investigator Lambert testified to that. And with respect to the argument that this is a prolonged detention, I asked Investigator Lambert how long it took him to arrive on scene. He said 5 minutes. Furthermore, his accident investigation did not even last 20 minutes. At about 17 minutes and 20 seconds on the video, you see him allow the other driver to leave. He then established reasonable articulable suspicion to continue holding Mr. Cahill. And after the other driver left at 17 minutes and 20 seconds, he was with Mr. Cahill on the scene conducting his DUI investigation for all of about 13 or 14 more minutes at the point in which he arrests Mr. Cahill. And the investigation is then complete. So I would respectfully request that the court deny defense's motion to suppress. State has established reasonable articulable suspicion, probable cause for the DUI arrest, and that this was not a prolonged detention.
Counsel.
Your Honor, our Court of Appeals and our Supreme Court continuously hold that a trial judge has the autonomy based on video evidence to determine probable cause based on video evidence over and over and over again. They've held that. One of the first things that I want to point out to Your Honor in this court is that based on video evidence, my client had sunglasses and a hat on and a mask. There were no manifestations, bloodshot watery eyes or anything you mentioned. And here's the most important thing in this whole thing, and I'll get into the field sobriety test just to add on, but also he never noticed, and this was stated 2 times under oath here, he never noticed or even determined that he smelled alcohol until he started conducting the HGN test, which is a filter body test. And he made him take off his hat and sunglasses. And then and he had already started filter body test before he ever even noticed the odor of alcohol. So based on that alone, Your Honor, I would ask the court grant my motion. But let's go to, we'll start with the HGN test when officers conducting HGN, especially 12 to 18 inches from their face. I've been through the same training, fortunately, as Officer Lambert, but
Your
Your
Honor,
Honor,
I would just object on the basis that his motions are not challenging the actual administration of the field sobriety evaluation in the HGN. We're just looking at reasonable articulable suspicion, prolonged detention, and probable cause.
I don't know what she had.
I'll let you
Okay.
make whatever argument. you
Your Honor,
want.
so Your Honor can watch, and I saw you watched the video. The stimulus was way, I don't know, I think he said it was his finger, was far exceeded 15, 18 inches from my client's face. That was so evident on the video that we watched. Your Honor, dealing with the HGN. And then, Your Honor, I would say that he did very voluntarily conduct and participate in the walk and turn. But the one leg stand test was the reason I asked him about that. Was these tests are supposed to be voluntary. They have to be voluntary. He just told my guy told Mr. Cahill to get in the one leg stance and immediately started conducting. There was nothing voluntary about the one leg stand test as that was conducted out there on the side of the road. But I would ask the court to suppress the one leg stand based on involuntariness from my client. But Your Honor, 2 times in this hearing, Officer Lambert admitted that he never even smelled alcohol, but until he started conducting the HGN test. And based on that, Your Honor, I'd ask the court grant my motion because that's almost investigating. There's no basis for the investigation. There's no smell of alcohol yet. There's no impairment. His eyes, he didn't take his sunglasses off until he started conducting the HGN. So, Your Honor, based on that, I'd ask the court to grant my motion.
Your Honor, if I may just briefly.
Yes.
Your Honor, with respect to the suspicion that he had of DUI, I think the investigator laid that out pretty clearly and articulated that pretty clearly. With respect to the administration of the HGN, that was not laid out in his motions. However, any issues with how it was administered would go to weight, not admissibility. And furthermore, with respect to the voluntariness of the field sobriety, well, specifically the one leg stand, you heard testimony from Investigator Lambert that he asked the defendant to perform field sobriety evaluations and he voluntarily agreed. I think that he's, admits that so much he agreed to do the HGN and the walk and turn, but he voluntarily agreed to do field sobriety evaluations. The one leg stand is a part of field sobriety evaluations.
Your Honor, I just direct Ms. Walter to my motions. Defendant's exclusion of the HGN test administered by the defendant on the grounds that the defendant was not it was not conducted properly under NHTSA standards. Your Honor, you can base your decision, the whole motion hearing based on what you saw on the video. And based on video evidence, I would ask the court to grant my motion based on lack of probable cause.
And Your Honor, that's the whole reason that we narrowed the issues down at the beginning of this motion. And I asked for them to be placed on the record so that we did not have this issue of bringing up things that were not going to be an issue. And so any other issues that were laid out in his motion, he's waived because at the beginning of this process, we put on the record exactly what was going to be challenged.
Yeah, she's using HGN to develop probable cause. I don't understand her argument, but I'll leave that up to the court.
Okay. I'll take it under advisement. I'll get your written order directly. Okay.
Thank you, Your Honor.
Okay.
That's all. We excuse.
Yes, you all have a good day.
Thank you, Your Honor.
Let's see, do we have anyone come in that we can take a plea on so that I can get those?
Yes, Your Honor, I have 2 cases that I was
Okay.
able to resolve.
And I already have paperwork on the Austin case. Is that one of them?
Miss Montague is the case, Miss Anna Montague. And I'm sorry, Your Honor, this is my first plea in absentia I've entered. I'm a little unfamiliar with the procedure,
Okay.
so please bear with me.
So it's two papers, I have two forms. That works.
Yeah, he should two,
Thank you so much.
yes. Are you finished with your? Okay.
So that's. How are you?
Yeah.
Little more confirmed. Maybe this is the situation.
Okay, let me just deal with this one now.
And that's what we just did. I'm sorry, I'm making it.
So Ms. Montague has two separate cases.
That's correct, Your Honor.
That's,
So on one of the cases, I do have Ms. Montague's signature. Oh. I just want to make sure that these go together. Do I have it?
I think this is very much a budget. I'm sorry, I don't know anything about the signature. We didn't have the breaking name, and these are. And we have.
it's okay. Good morning. Just if you just-
No, it does not have my name.
Do you want to hand that back to,
So I can just check over it. Yeah, she didn't.
would you all check over this paperwork? Again, anything else that I can take while y'all are doing that?
Yes, so it's still dog client position, 3 on the calendar.
Okay, I have signatures. Here.
So upstairs, the wall.
Oh, right there.
Oh, no, imagine.
Right.
Yep.
There's that one. You just print it twice.
Is it Chakravarti? Okay, correct. Yeah, all right, good morning.
Good morning.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. Place your hand down. Yes, Ms. Meisner.
Yes, Your Honor. The state and defense have come to a negotiated agreement on this. The state will be amending the charge to a reckless driving. The recommended sentence is 12 months of probation, a $700 fine, an alcohol drug evaluation, and any treatment of deemed necessary, 1 risk reduction, and 1 victim impact panel. And the state is agreeable to termination upon completion of all the conditions.
That is the negotiation, Your Honor. It may be a little curious just because there's no community service. We raised the fine. As you may see, my client's expecting her first child in about 2-3 months.
All right, congratulations.
Thank you.
Ms. Chakravarti, it's my understanding that in case 21 CR 006526A, you wish to plead guilty to reckless driving. Is that correct?
That would be correct.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Once you complete the terms, the probation will terminate. So the sooner you get it done, the sooner that you won't be on probation and have to pay those fees. We'll give you, if we have not already, the form where you need to report to probation. If you can do that in the next 2 weeks or so, that would be appreciated. Anything further?
Judge, I filled out the intake, but I just need the form that shows where to go.
Okay, we'll give you a copy of that.
Sure. Thank you so much, Ryan. Nice to see everyone.
Thank you.
Good luck to you, man.
Good to see you. Thanks a million. Nice job. Mark, you did kind of over.
Yes. Your Honor, Ms. Bolton.
It's $700 fine, correct?
Yes,
Okay.
and I'm filing down the amended accusation.
Or can you do that?
Yeah, I'll do the bid one.
Oh, I'm sorry.
And are we ready to proceed on the Montague matter? All right, the court calls the cases of State of Georgia versus Anna Montague, case 17 CR 025391G, and case 17 CR 020349G. It's my understanding that will be a plea in abstention. Is that correct?
Yes, Your Honor.
Would you like to give me the facts?
Sure. And let me put myself on the record. I'm
Oh.
Andrew Fleischman here for Ms. Montague.
Yes. Good morning.
Good morning. I'll stipulate to the facts.
Yeah, thanks. And then Judge, based what's written on the plea and plea and abstention paperwork, I believe I'll be amending both of those to driving without a valid license, one with a $300 fine and one with a $500 fine. And I did negotiate that with defense counsel.
Okay. And is Ms. Montague going to be paying these fines contemporaneous or
Today, Your Honor.
today?
Yeah.
Okay. And
So I probably will need the court's advice on how to go pay those for her, so she'll get me back.
okay, so we can either get those paid either online or you can go up to the clerk's office and get them paid, knowing that it's will be with surcharges also. And this is, I'm sorry, could you place your name on the record again for me?
My name is Andrew Fleischman. I'm here with Sessions and Fleischman.
Okay,
And Sessions Park.
and Mr. Fleischman, you had the opportunity to go over the guilty plea statements with your client,
Yes, Your Honor.
and you went through those statements line by line with her.
Yes, Your Honor.
And it's my understanding that she's pleading guilty to those charges.
That's correct, Your Honor.
Okay. Accept her pleas, 2 counts of of driving without a valid license. My understanding that the fines will be paid today, and once they are, that'll dispose of the matter.
Thank you so much, Your Honor.
All right, Mr. Fleischman, good to see you.
Good to see you. Nice to meet you.
Good to see you.
Does he, I've got approved by defendant's attorney. We need to get, before you go, Mr. Fleischman, before you go, I have a signature line for Mr. Sessions.
I will go ahead and sign for him.
Okay. Thank you.
Yeah, I'm gonna borrow you.
Okay, fine.
Do we have another case that's ready for a plea?
I don't think we have anyone, please, Your Honor. So I understand there are two motions left.
Okay. Did we ever find out about? Sir, what? Thank you so much. Ms. Branson. It's not, okay, no, that's fine. Do we know what's gonna happen with this Austin case? Brandy?
Austin,
Right, are they here?
do we know what's gonna happen
What? I don't.
to the Austin case? Or Austin?
Oh, that's a plea.
Right,
Oh,
Sorry.
I think 1:30. I can call them and see if they can get
it's
us.
my understanding that they were gonna be here at 9 today.
I sent them the link. Let me call them.
Okay.
Your Honor.
All right, the next case that I have in line is position 4, Terrence Johnson. Or Mr. Johnson,
Good morning, Your Honor.
good morning, how are you today?
I'm good. Thank you for holding for my report. I was up in Judge Richardson where this case started and they told us there's no court today. We
Okay,
had to find you guys. This is my first Orca case.
oh, okay,
Good
very
to see you
good.
this morning. Judge, with me this morning, I'm Forrest Butterfield for the record, Your Honor. I've appeared before this honorable court before.
Yes,
Here on behalf of Mr. Terrence Johnson, but also with me is Ms. Shanae Hall. She's a 3L sworn in under the Third Year Practice Act. So she's been working with me, going to court, taking pleas. She will be sitting with us. Your Honor.
very good. Welcome, Ms. Hall.
Thank you so
Good to
much.
have you. This is the case of State of Georgia versus Terrence Johnson, case number 22 CR 002085F. And again, if we could, I've got a number of motions. Have you all clarified what we'll be moving forward with this morning?
Your Honor, I'm not sure about the defense motions for discovery. The state has a response for moving forward on discovery, but the only one I'm aware of that we're moving forward is a notice of intent to introduce prior bad acts or 404B, Your Honor. And
Okay,
403.
is that correct, Mr. Butterfield?
That is correct, Judge. There was an original notice filed by Jordan Riser when he had the case, when he was inactive on the case, and then the state did supplemental or amended notices. So in essence, this is a case briefly in which Mr. Johnson's charged with battery. And in this case, the state wants to present evidence of prior bad acts or other evidence case, and they have listed what those things are. It's my understanding one of these cases involves a 2018 case in which Mr. Johnson was accused of aggravated assault, and they want to bring that in. But the witness, I understand they just provided a few minutes ago, noticed that that person is in the hospital. We definitely need that young lady. The seriousness of that case, we need her here to cross-examine her. In essence, my clients would say he was robbed, gun went off, lady got shot, but that's one. A second one is Mr. Johnson allegedly found some ID, and when he was stopped by the police, he presented that. He was charged with ID fraud, but it got reduced. He took a plea to disorderly conduct. And then the third one is he has a pending aggravated assault charge pending here in Fulton County. The state wants to get in that evidence also. And they allege that, it's exceptions under the general rule of bad character evidence not coming in. So they'll say motive, intent, absence of mistake, and all this whole laundry list. So that's where we are. But it's my understanding, one witness isn't here. And on this other case, I believe that I had given the state everything, but it's in Superior Court. So there were videos in the 2022 case. I'll give you the CP number for that, Judge. It's 22 CP. I'm sorry, Judge, forgive me. 22 CP 213811, charging ag assault, possession of a firearm during the commission of a felony. That case has been unindicted. It's been around. He was arrested back on November 8th, 2022 on that matter. But in that case, there was a big preliminary hearing. I had a transcript. It was given to the prosecutors. I didn't realize, not the state prosecutor, it was given to the DAs. We actually had a hearing. State had a copy too. There are also videos that from the time he was arrested and we sought bond, I had forwarded that to several ADAs. So my thought was I had already given it to them, but I realized we talked today, Mr. Jacob Stevens here, that didn't have those things until this morning. So bottom line, judges, I believe that the course of conduct would be that we put this matter off because of the fact that the state just got the videos in the transcript, and because we're going to have this witness who was in the hospital has to be here to testify about these allegations. It can't be done by just proffer. So that is what we say. We briefly chatted, our prosecutor and I talked about the course of how to proceed on the matter.
And Your Honor, I've been able to talk to the witness at least somewhat. I haven't discussed with Linda Butterfield, but we are ready to proceed on one of the offenses, Raven Neal. She's in the courtroom today. She was the witness he's referring to that having the aggravated battery, the open aggravated battery. In general, starting at the beginning, Your Honor, in terms of the 2018 incident, the one that's he's referring to is unavailable. I have sent Ms. Bolden and the defense the hospital admittance record. She's currently in the hospital right now. The reason why she's in the hospital is actually from that gunshot wound that she received when he was robbed. It was actually at a birthday party, and at that birthday party, he shot and she was hit. They weren't boyfriend and girlfriend at the time they used to be. In terms of what she would testify to, it's in the notice that she would testify to their nature of their relationship prior to them breaking up, the nature of the domestic violence that occurred, as well as what happened on that night, where she does not believe it was reckless conduct. She believes it was intentional. But as the defense mentioned, that's something that we need the witness to be able to be here for, unless the defense is willing to accept the proffer. But the defendant is currently in the hospital from a wound that she received from the defendant. In terms of the identity fraud, bring down to the disorderly conduct, that one point forward of impeachment, regardless of whether or not he found an ID or whether or not he stole it, doesn't matter. He presented someone else's ID when he was stopped, and was reduced for disorderly, but that's for impeachment, not for the 404. And then finally, for the last case, the open aggravated battery, again, the victim from that case, Ms. Raven Neal, is here in the courtroom. We're ready to do direct examination, cross-examination. I've been able to review the videos and text messages he sent me this morning. I'm prepared to move forward on that particular witness, but I also understand that we do not have the one that's currently in the hospital, Your Honor. So if we could hear at least some and get out of the way before trial, or if you would like to move it all the way till prior trial so that we have all the witnesses available.
It would be the court's preference. It's easier for me to hear everything at one time so I can put it all into context. I understand that one of your witnesses is here, one of them is unavailable. I hate to inconvenience the one that is here, but I prefer to do it all at one time if that's,
And like I said, we can make a proffer to the nature of her testimony if the defense is willing to accept, but that's if the defense is willing to accept.
We're not accepting any proffers. It was a very lengthy preliminary hearing on, we challenged that entire evidence, and that we think, the videos are going to be relevant. And in essence, Judge, in that we don't accept any proffers. We're going to have a hearing on it, Judge.
okay. In that case, I would prefer to have this all at one time. Mr. Stevens, if you all can agree upon a date, and I don't know how long the young lady will be in the hospital.
She's Your Honor, I'm trying to see when she's available. She's in and out of the hospital. For the court's understanding, this is not relevant to the case, but she didn't have insurance at the time she was shot. So she's in and out of the hospital, and this would be chronic life pain for her. So she goes in and out of the hospital frequently, from my understanding. But I'll try and work out a specific date when she'll be out.
Okay, and this is a relatively old case, 2020. I don't mind putting it on another motions calendar at the convenience of everyone that's involved, but I would prefer to hear it all at one time.
And just so we can potentially stipulate now, defense or Your Honor, would you be, if she is frequently in the hospital, would you be open to her appearing virtually to be able to testify?
We would like to have a cross-examination with her here. And we'll say, Judge, this is 5 years ago. I understand what the state's been alleging, and we understand there was a shooting, but we need her here to testify. He want her to be present.
Okay,
Yes, okay.
all right. And my inclination would be to put this off until sometime first of the year on another motions calendar. Would that be satisfactory to?
Yes, Your Honor, and I'll reach out to our other witness within this week so we can try and confirm whatever date needs to be. And if it needs to set a specific date for trial or for motions, we can do that as well. I'll speak with Attorney Butterfield about it as well.
Yeah, I'm generally going to be available. So if the state gives me some proposed dates, I'll just make sure. But I think I'll just get the dates from the state, and I'll be able to agree with a date. I'll just wait for them to give me a date, since we can't just set a date now without having heard from the witness, I guess.
Okay, so what I'll do is I'll further notice this. If you all will get with Ms. Bolton to get a date first of the year that's satisfactory to everyone, where I'm on the bench, then I'm happy to move it to the first of the year.
All right, thank you, Judge. I'll wait, and then after we get the date, maybe we then be excused. That will conclude our business for today.
Okay, I don't know if you're gonna be able to get the.
Oh, we can't get it today. Okay, all right.
Okay, but
We only have dates up until
Understood.
December 13th, 14th, and 15th. We don't have January yet.
Well, I'll wait to hear from the state and the court's case manager about the dates. And like I said, I'll be able to just, whatever the dates are, I should be able to, after, I'll be able to pick a date that it's not going to be a conflict.
okay, and again, I apologize to the witnesses that are here that you'll have to come back. Thank you for being here this morning. And I'm sorry for the inconvenience today, but we appreciate it. Okay. All right, very good. If nothing further, you all have a good rest of your day.
Thank you very much, Your Honor. We'll wait till they leave. Let's wait till they walk out.
That's fine.
It's one needs. Attorney Butterfield, he needs copies.
Okay, the next case that I have is Thomas Whitmore. Are we ready to proceed on that matter?
Yes, Your Honor, we're ready to proceed. Trooper Buffington is here. I believe Attorney Thomas is here, but he might have stepped out for a moment.
Ms. Waldrop, were you able to raise?
I wasn't, so I sent him an email, but I'm gonna keep calling him.
Okay. Okay, that, court calls the case of State of Georgia versus Thomas J. Whitmire. Case number 22 CR 0015006F. Charged with driving under the influence of alcohol less safe and driving under the influence of alcohol per se. Counsel will identify themselves for the record.
Yes, Your Honor, I'm Thomas James Thomas, representing Mr. Whitmore.
Good morning, Mr. Thomas. Mr. Whitmore.
Your Honor, Jake Stevens on behalf of the state, is my understanding that the defense filed a number of motions. However, the only one I'm aware that we're proceeding on is the roadblock motion, the constitutionality and the roadblock.
Yes, Your Honor.
Okay. And what were, I do have a motion,
There should be a motion to suppress, Your Honor, which I think contains the roadblock.
okay, all right, but the only part of the motion to suppress that we're proceeding on would be the roadblock.
Yes, Your Honor.
And what, and with all the, what happened to the rest of the, if there's not?
Well, I've since then I've reviewed the video, the police reports and so forth. And I think the only thing in controversy are the road standards for the roadblock. And
okay,
there's no argument that he was stopped in the roadblock. There was no other reason for him to be stopped. So it would be just the 5 principles of constitutionality of the roadblock that LaFontaine has laid out. And so,
okay, I just wanted to make sure that I wouldn't have to come back for other motions to suppress on.
no. Actually, he did pretty well in the field test. So I kind of like those. We shall see.
Okay,
Okay.
all right, you can proceed, counsel.
Sorry, I assume the defense wants to make opening statements. If not, the state's prepared to make opening statements on the motion and then call witnesses.
I essentially already made it, Your Honor. There's no other reason for him to be stopped with the roadblock. So therefore, we're challenging the LaFontaine principles that the roadblock was constitutionally constituted. It was authorized by supervisory personnel for a reason other than just stopping citizens, and that every car was stopped and so forth and so on. Just the criteria there, Your Honor.
Okay.
And Your Honor, the state is going to ask that you deny the defendant's motion to suppress on the grounds of the roadblock being unconstitutional. Under Fontaine and under Turner, we will argue that the roadblock was the decision to implement the roadblock was made by supervisory personnel versus officers in the field, that all the vehicles were stopped opposed to random vehicles, that there was no delay to the motorist or the delay was minimal, that the roadblock operation was done by well identified as a police checkpoint, and that the screening officer, Officer Buffington, had reasonable articulable suspicion to refer to defendant for further detention in the field sobriety test. And Officer Buffington will be available to testify. He will say all those things, as well as we have the roadblock permission slip by the supervisor and the final report to introduce into evidence as well. Further, depending on further rebuttal, the defense is ready. The state is ready to proceed.
Okay. You can proceed.
The state calls off Trooper Buffington to the stand. Good afternoon. Could you please,
You'll swear him in, please.
Do you swear from testimony about to give today before the court the truth, the whole truth, and nothing but the truth, so help you?
I do.
Yes, my judge.
Thank you.
Good morning. Would you please state your full name and spell it for the record?
Yes, it's Trooper second class, Jordan Buffington.
And Trooper Buffington, thank you for being here today. How are you currently employed?
With Georgia State Patrol, Nighthawks North, DUI Task Force,
And how long have you been employed there?
since 2017.
So would your period of employment cover May 29th, 2021?
Yes, sir.
And what training have you received as a GSP officer?
Standardized field sobriety, A-Ride, advanced driving, firearms, well, very extensive, about a year's worth.
And what's some of the testing that goes into A-Ride, field sobriety, and so such certifications?
Each portion of it, field sobriety has classroom portion, wet labs, so on and so forth.
And have you completed all those trainings?
Yes, sir.
Have you received certification for all those trainings?
Yes, sir.
And were you certified on May 29th, 2021?
Yes, sir.
How many approximate DUIs have you handled?
Not sure, a lot. Actually putting the number on DUI arrest, I'm not sure. I probably did field sobriety a couple thousand times, I would estimate.
And have you ever done a police checkpoint outside of the state?
Outside of the state?
Outside of this date? on May
Oh,
29th?
like other than the date?
Other than this incident date, have you ever done or have
Yes,
you ever
sir.
been a part of
Yes.
checkpoints?
Mr. Stevens, could you pull your microphone up a bit?
Yes, Your Honor. Apologies. Your Honor, may I approach?
Yes.
Witness. Showing the defense counsel. Your Honor, would you like to see a copy of this with you?
No, please. And make sure that for the court reporters' benefit that you talk into the microphone. Oh, you're gonna ask them? Okay,
Can I ask a preliminary question, Your Honor?
yes.
Was this document prepared by you?
No, sir.
Your Honor, I object that it's hearsay.
Your Honor, I haven't even gotten to the foundation of this yet.
Okay. Reserve ruling.
Trooper Buffington, to your knowledge, was the supervisor approved the checkpoint on May 29th?
Yes, sir.
Objection, that would be hearsay if what the supervisor approved. He couldn't have any knowledge of what was inside the supervisor's head. There's a case specifically on point that officers cannot testify as to what was in the supervisor's mind when he authorized the roadblock. It's Blackburn versus the state, 5256 Georgia Appellate 800. Trooper identified the roadblocker status and so forth, but he was not, Trooper was not the supervisor, and therefore the evidence was hearsay.
Your Honor, I'm not asking whether or not he knew what was in the supervisor's mind. I'm asking, is he aware that the checkpoint was approved by a supervisor? Check to see if you had any knowledge of the checkpoint and was that checkpoint approved?
That would be the same thing as him testifying that a supervisor took some act, and it would be clearly hearsay because he's not the supervisor.
Your Honor, a couple of responses. One, what it goes to his personal knowledge, whether or not he knew that the checkpoint was approved or not. The report that goes to his personal knowledge and what he spoke to or what he experienced from talking to his supervisors. That is personal knowledge, especially if his supervisor was there. Secondly, this is a motions hearing. Oh, sorry, apologies.
Slow it down for me so I can.
Secondly, this is a motions hearing where hearsay is allowed because the court is presumed to be able to separate prejudicial versus probative information. And the witness is allowed to testify as you, Your Honor, are able to use your discretion whether or not you will hear such evidence. And finally, again, this is not hearsay. This is whether or not from his own personal knowledge was the roadblock approved by a supervisor. If he knows that it was approved, regardless if someone told him or if he was there when it was approved, it depends on his knowledge. So I'm asking, to his knowledge, was it approved?
I'll allow it over objection for the purposes of this hearing.
Trooper Buffington, would you please answer the previous question? I can restate it if you need me to.
Yes, sir. I knew that the supervisor approved the road check.
Do you know who that supervisor was?
Yes, sir. At the time, it was Sergeant First Class Logan Gass, now Lieutenant Gass.
And Officer Buffington, have you seen the supervisor form for the roadblock?
Yes, sir.
And have you seen the final report of after the roadblock?
Yes, sir.
Would you recognize that if it was placed in front of you?
Yes, sir.
Your Honor, I've already shown the defense counsel and the court needs to see, but I've shown the counsel, I placed something in front of the defendant, sorry, in front of the witness. Trooper Buffington, do you recognize the piece of paper I placed in front of you?
Yes, sir.
How do you recognize it?
It's our departmental roadblock form filled out for that date.
Filled out for what date?
May 29th, 2021.
And just to be clear, could you say a little more clearly, what is it exactly that you see? Or what is it that's in front of you?
It's our Georgia State or Georgia Department of Public Safety roadblock final report.
And as a fair and accurate copy of the inspection and the report that you had previously seen?
Yes, sir.
Your Honor, for the purpose of this hearing, the state would like to admit into evidence the roadblock inspection and approval as well as the final report.
Objection hearsay. It wasn't prepared by this officer. He couldn't even get his own police report in. Those are not allowed either in evidence, Your Honor. It would just be what he testified to and what his observations were. And this document doesn't have his observations, his testimony, what he did. This is another officer's report. Therefore, it's clearly hearsay, Your Honor.
For the purposes of this hearing, I'll allow it.
Trooper Buffington, on the front side of the supervisor approval, does it list the officers that were allowed to conduct the stop?
Yes, sir.
Can you list some of those officers? Or sorry, list all the officers?
Continuing objection to anything in this document, Your Honor, as hearsay.
I'll give you a continuing objection.
It's just to speed things up, Your Honor. Thank you.
Thank you.
Could you read the names of the officers that were included?
Yes, sir. Sergeant First Class Gas, Sergeant McAdams, TFC Ganell, TFC Clark, TFC Mullen, TFC Buffington.
And Trooper Buffington, is that TFC Buffington you?
Yes, sir.
So you were personally on the approval form and you were personally involved in the checkpoint?
Yes, sir.
Thank you. Trooper Buffington, what was the purposes of the police checkpoint?
License check, check for impaired drivers, seatbelts.
And Trooper Buffington, does that report say, does it have any markings as to identify what exactly was the reasons?
It does. Yes, sir.
Would you read what those are?
Driver's license / insurance / registration verification, seatbelt compliance, driver impairment, vehicle fitness / vehicle safety compliance.
And Trooper Buffington, on the day in question, were you in full uniform?
Yes, sir.
Were you in a marked patrol car?
Yes, sir.
Were there other officers present?
Yes, sir.
Were they in uniform?
Yes, sir.
And did they have marked patrol cars?
Yes, sir.
On that report that you have in front of you, is there any markings that point to whether or not there is patrol cars that were in uniform?
I believe so. Yes, sir.
Could you read those?
6 marked GSP cars, blue lights, 6 uniform troopers, and reflective vest.
Thank you. And just to be clear, in case we haven't said it, who is the supervisor listed as the approval authority for this roadblock?
Sergeant First Class Logan Gas.
Now, Trooper Buffington, on this day, May 29th, how were the vehicles stopped at this checkpoint?
As explain what you're.
Were all vehicles stopped? Were only some vehicles stopped? How did y'all conduct the checkpoint?
All vehicles were stopped.
And how long were the motorists detained for or stopped at this checkpoint?
Minimal delay.
Approximately how long?
Time frame, I don't know. It's minimal.
Would you say between 15, 30 minutes to an hour? How long would you say?
You talking about each vehicle?
Yes.
No, just long enough to verify license, the impairment, all that stuff. Maybe guessing estimate, probably 15 to 30 seconds per vehicle, if that, maybe.
And in regard to this defendant, how did you come into contact with Thomas Whitmore?
He was traveling, I'm pretty sure it was eastbound, possibly, on Habersham Road, and came through the road check.
And had you ever met Thomas Whitmore before that night?
No, sir.
Do you recognize Thomas Whitmore in the courtroom today?
Yes, sir.
Would you please identify him for the record?
He's in a blue suit.
And Drew Buffington, when you came into contact, why did you come in contact? What was the reason for speaking with Mr. Whitmore?
He was the driver, Toyota, I think it's Toyota 4Runner possibly. Yes, sir. Toyota 4Runner.
I'm sorry, could you say that a little louder?
He was the driver of a Toyota 4Runner.
And what did you observe upon coming into contact with Mr. Whitmore?
While speaking to him, observed a strong odor of alcoholic beverages coming from his breath and bloodshot watery eyes.
And what did you decide to do upon observing these manifestations?
Had him pull over to the side out of the roadway, had him removed from the vehicle and asked him to agree if he would agree to stand around field sobriety test.
And were you certified to conduct those standard field sobriety tests at the time?
Yes, sir.
And then the roadblock itself, was it identifiable to other drivers on the road?
Yes.
How was it identified?
Through 6 marked patrol cars, us in uniform and reflective vest.
Your Honor, I can stop here based off of the motion itself. I can continue if the defense wants to go into the FSTs, but for the purposes of this very limited motion, the state has concluded its questions of the witness and will recall it necessary based off of the other motions that might come up. But at this point, the state has no more questions.
Okay, Cross.
Bill Cross, Your Honor. Thank you.
Thank you. We appreciate you being here.
Yes, sir.
Anything further?
Just the state's will be the state's response to the closing argument.
No witnesses, Your Honor. I'm sorry.
Okay, very good. Yes. Steve.
Yes, Your Honor. So the state requests that you deny the defendant's motion to suppress. We would cite LaFontaine v. State 269, sorry, apologies, Your Honor, 269 GA 251. That's a Supreme Court case out of 1998, as well as Turner v. State 352, Georgia Appellate Court 122, case out of 2019.
Do you have copies of those for the court?
I do not, Your Honor.
Can you get me copies?
Yes, Your Honor.
Okay. Go ahead.
Your Honor, both in LaFontaine and Turner v. State, the Supreme Court and Court of Appeals has held that there are very specific articulable factors to determine whether or not a stop is constitutional. I'll give you a moment, Your Honor. Okay, and I'm citing directly from LaFontaine. It's been held that the police officials may set up highway roadblocks for the purposes of requiring motorists to display their driver's license, and that such practice does not invade their right to use the public ways free from unreasonable and unwarranted exception. Nor does such practice constitute an unlawful arrest or an illegal search, as contrary to the United States Constitution. The state can practice preventative therapy by reasonable road checks to ascertain whether a man or machine meet the legislative determination of fitness. And the specific articulable factors that they laid out to determine whether or not the roadblock is constitutional is that they must determine that the roadblock is satisfactory and that the decision to implement the roadblock was made by supervisory personnel rather than officers in the field. All vehicles were stopped as opposed to random vehicle stops. The delay to the motorist is minimal, and that the roadblock operation is well identified as a police checkpoint, and that the screening officer at training and experience is sufficient to qualify him to make an initial determination as to which motorist should be given field tests for intoxication. As True Buffington testified to, as well as the report that was introduced into evidence, it shows that Trooper Gast was the supervisory authority, that he was the supervisor that authorized the checkpoint, that at the checkpoint there was at least 6 officers in well-identified uniforms in 6 different GSP vehicles, police vehicles, that it was identified to all motorists on the roadway, and that every single vehicle was stopped, that there was not a random search, that every person that had to go through the checkpoint, that the delay was minimal, and that as Trooper Buffing testified to. If they had their registration and their license, it could be 15 to 30 seconds, unless in the case of the defendants, there's more reasonable articulable suspicion that they need to be pulled over for more field sobriety tests for impairment. The officer testified that he has training in field sobriety and A-RIDE, and that he has been certified numerous times, and that he has passed all certifications. He had that certification the night of May 29th, 2021, where he was employed as GSP officer. And then he pointed to the articulable factors that he observed before he conducted the field sobriety test, before he was able to pull them off. That included bloodshot watery eyes, slurred speech. He talked about the numerous things that he observed, and the odor of alcohol on the defendant's breath. So he testified to reasonable articulable facts that led him to have a suspicion that the defendant need to be pulled over for further field sobriety. Given that all these factors laid out by Turner and the Court of Appeals, as well as the Supreme Court, have been met by not only the piece of evidence that was admitted itself, but also by Trooper Bovington's own testimony, the state again asked that you deny the defense motion to suppress. Thank you.
Thomas?
Thank you, Your Honor. No, the standards set out by the Supreme Court have not been met. They're very specific about this in Brown versus the state, 293 Georgia 787 Supreme Court case. Supreme Court held that in order to be a lawful roadblock, the checkpoint must be authorized by a supervisor and must also reflect probative program purposes other than mere crime control. In other words, you can't just set roadblocks up and say we're stopping crime, and a supervisor has to make that specific decision, lay out what the program is, why this is not just stopping citizens as they drive down the road. This exact same question with who's qualified to testify about that was considered in Blackburn versus the state. So I've already mentioned that's 256 Georgia Appellate 800. Trooper testified the roadblock was established by his corporal and so forth and so on. It was ruled to all be hearsay, and did not meet the standard of the supervisor saying, "I'm the supervisor. I'm allowed to do this. This is my program. These are my program purposes. This is why it's not just general crime control. I'm not just blocking off the streets. This was my motivation. This was what the document that officer did. He was just reading somebody else's document while I was objecting to hearsay. He didn't prepare that document. He doesn't know what it was in his head. Nothing. It wasn't a business record exception. There was absolutely no reason why document not prepared by this officer should be admissible. It's not true that hearsay laws do not apply to probable cause. They just as a dead document. The hearsay, if objected to, applies at all times in most situations. The specific question has been addressed about whether or not one of the patrol officers or the officers conducting the roadblock can actually testify what was going on in the supervisor's head. And the answer is no, it can't be. There's even some question whether the supervisor should be involved in the roadblock or not, or whether they should be completely on another strata. But that's of course I'm a little foggy about that, whether the supervisor can stand around and sort of participate. But it's clear that there must be a supervisor. You must be authorized. You must hear from that person. You must be able to go over what his purposes were and what and just having a paper prepared by a person who's not in court and cannot be cross-examined. I cannot get into what he was thinking at the time. Of course, it made a very strong emphasis about that. We've already ruled on this question. You have to have the supervisor here. They have to testify directly. Therefore, the most primary and most important of all the LaFontaine rules that it can't just be a roadblock thrown across the street. It has to be by a supervisor who has thought through this on a program level and can explain exactly why this met his program standards. And it was not just general crime control. I'd love to hear all that. I can't hear that. We know that this was not the supervisor. There was another, there's a Trooper Goss, who's not here for me to cross-examine. Therefore, Your Honor, the state has not met its burden.
The site for Brown versus State again.
Okay, I'm sorry, Your Honor. Of course, I closed the book right when you asked me an important question. Brown is 293 Georgia 787, decided in 2013 Supreme Court case, and the Blackburn case saying the hearsay is not sufficient. 256 Georgia Appellate 800 cited 2002.
I'm sorry, 256 Georgia Ave.
Yeah, Georgia Appellate 800. Sorry, Your Honor. My coffee's still kicking in here.
Okay,
So
you're fine. Okay,
there's a chain and string of cases, but it's all kind of the same thing, that they have to have the supervisor here and
okay.
and it's hearsay otherwise.
So these, any other cases aside for these two that you'd like me to consider?
I'm trying to get a more recent, these are just chain sites, Morgan, State versus Morgan, 267 Georgia Appellate 728, 2004, Morse versus State, 65 Georgia Appellate 186, 2003. They're all kind of the same thing. The state somehow tried to get around and not having a supervisor, and it didn't work.
Anything further, Mr. Stevens?
Yes, Your Honor. One, the factors that have laid out by Fontaine and by Turner in 2019 are very clear as to the factors they need to be considered. Those have all been met by Trooper Buffington and by the evidence that was introduced. In terms of whether or not this is done for more than just a perfunctory stop, again, the trooper testified to it, and I also read from the report that this was done in order to consider driver's license, insurance, registration verification, seatbelt compliance, driver impairment, and vehicle fitness and safety compliance. And as I read from, apologies, Your Honor, as I read from LaFontaine, all those are valid reasons to test for the driver as well as the vehicle's fitness. That's constitutional under Georgia law. In terms of having the supervisor here, again, Trooper Buffington testified to that not only was the supervisor present and that his name as well as Trooper Buffington are on the report, meaning the Trooper Buffington was there with Trooper Gast. He was present at the stop, and the supervisor set this up ahead of time. Again, if Your Honor would like a copy of the report, it says data authorization, May 29th, 2021, time of authorization at 1830. The roadblock did not start until 2230, meaning that the supervisor did not just throw up a random stop. He approved it. They set it up and then they began. It was not done by officers in the field. It was done by supervising authority, done with Trooper Buffington present, and it was done according to Georgia law for valid reasons. For that reason, again, we ask you deny the defense's motion. Thank you.
So, but it's my understanding that his objection really is that the supervisor is not here so that he can cross-examine the supervisor as to why the supervisor initiated a traffic stop to begin with, and if that was properly initiated, if I'm understanding counsel's argument. And I'll read the cases in that regard. But I think that I understand your argument about how it is, how you can do it and is proper, but I don't think that's his problem. If I'm with that today, that's why isn't the supervisor here to testify in this regard? I guess would be if he's the one that initiated it all, then why isn't he here to be cross-examined as to whether it was proper or not? I don't know if this officer or this trooper can testify as to whether it's proper or not, but I'll take a look at the cases in that regard with what counsel is telling me. But I think that really is the issue. Do I have that right, counsel?
Yeah, yes, Your Honor. There has to be a supervisor, and he has to go through some program purpose why he did this roadblock, or maybe this location, or there were reports of problems, or who knows. I don't know why they established this roadblock, and that is the person who has to make this decision. And they've made very clear that there's a supervisor makes that decision, and then these officers implement it. They may stop every car and they may properly get you out of the car, but the purpose of the overall roadblock, we have to hear testimony about that. And I have to cross-examine it, and we don't have it. So
okay, what I'd just like to say, just all the way around for everyone, that it's once a motion is filed, if you would put everything in the motion as far as the things that you'd like everyone to consider, it's much more difficult for the court to hear your arguments and to hear and to hear the specifics of what you'd like the court to consider without it being specifically in there. And then the rebuttal to that, it would be not sufficient also. So for both parties in the future, I'd like to, for whatever you'd like me to consider, legally, case-wise, I'd appreciate having a copy of it, that it being presented to both sides prior to the hearing, so that we can narrow those issues before getting before me. Is that fair? Okay.
I'm sorry I didn't bring the case. The motion was the defendant seized by Trooper Buffy and Georgia State Patrol at an unauthorized roadblock and had been pre-approved by supervisor personnel. That was the issue, which is number one thing.
Okay.
So, but I should have brought the cases in.
No, you're fine. I'm just saying, it just makes it, I think, easier for everybody all the way around, to have everything that will be considered. And I understand you all are busy. I get it. But so what I'm going to allow in this case is that, and I don't know if, Mr. Stevens, if you've had an opportunity to review, Brown versus State or Blackman versus State, or if you.
And Your Honor, I have Blackburn State pulled up. I understand you're going to review it, but if I could read a portion from that really fast, I would like to put it on the record, Your Honor.
Okay, go ahead.
Your Honor, so it says that I'm going to read a little portion. A police roadblock is constitutional, provided that decision implemented goes to the factors. Moreover, the supervisor official must have a valid primary purpose for the roadblock, merely than seeking to uncover evidence of ordinary criminal wrongdoing. And then establishing the lawfulness, the state has a burden of presenting some admissible evidence, testimonial or written, that supervisor officials decided to implement the roadblock and decided when and where to implement, and it had a legitimate purpose. So the state would argue that one, we have testimonial from the Trooper Buffington who was there with the supervisor, who was there present, and we have presented written evidence of the Georgia Department of Safety roadblock supervisor initial approval form, as well as the Georgia Department of Safety roadblock final reports. Again, with the supervisor's name, with the supervisor's rank, we have prevented testimonial and written evidence according to Blackburn. It does not need to be, as the defense cited, the exact supervisor that gives that evidence.
Okay, anything further?
You can't walk into any court with some document signed by some other person and say this works. It's not hearsay. And there has to be a hearsay exception for why a document can be admitted that wasn't prepared by this particular witness. I can't cross-examine a document. The case is, did the supervisor do it for a legitimate purpose? That's really what the case said. And we don't know, because I can't cross-examine. So I have no idea what his motivations were. And that document can't be admissible. There's no hearsay exception to put that document in that I've heard.
Okay, I'm going to take all this under advisement. If there's anything that anybody else wants me to consider before I make a ruling on this, if you will get me a brief on it, I'm happy to consider it. I'll be making my ruling, let's just say next week. So if you get me something by the end of this week, or the weekend, I will certainly consider anything further, get it to the other side also. But I'm going to take a look at the cases that you've cited and the cases that you've cited, and I'll make a ruling. Okay.
Thank you, Your Honor.
All right. You all have a good day. Okay. We're done.
Is the trooper excused, Your Honor?
Yes. Thank you, Trooper Buffington. Appreciate you being here today. And no word on Austin or?
Your Honor, he texted me back. He said he thought it was at 1:30, and I'm trying to see if he can get him and his client on.
Okay. Got it. Did we not confirm with him yet?
What is in
First, put it in order.
Yeah.
Oh, I'm sorry, right?
Okay, so the morning calendar is concluded. Thank you all. The afternoon calendar is my understanding that's going to be rescheduled. So that will conclude for today. Tomorrow morning's calendar, those have all either been continued. The afternoon calendar, we do have a bench trial and possibly a plea. All right, thank you all. I will see you tomorrow.
Have a good afternoon, Judge.
All right, thank you.